Hello, testing.
Testing.
So I
Garrett,
guess
are you testing?
Oh, am I testing? Hello. Tested? Did that do anything? I may not be on. Wait, now I'm on.
Yep.
say something else,
Something else.
Professor.
All right.
Jabberwocky.
We had
maybe.
these on. We were chatting downstairs. You guys didn't hear all of our
You were talking
conversations.
about the
did you?
mob downstairs.
That we were talking about all kinds of
About the
stuff.
mafia. Yes.
Testing. Sounded like amplified.
So everybody can hear everybody? Okay, welcome, folks. My name is Diana Ingram. I'm the executive director here at Hill Center at the Old Naval Hospital. I'd love to know, is there anybody who has never been in this building before? If you'd raise your hand. Welcome. Come back.
I'm the only one.
Look at all of our information and go to our website. Please check out, there's lots of information on your seats, not only about the exciting events happening this weekend, but into the future. Welcome to the opening edition of the 4th annual Benjamin Drummond Emancipation Day celebration, the first freed exploring African American life and culture by commemorating the end of slavery in Washington, D.C. This series was named to honor this Civil War era hospital's first admitted patient, a chap by the name of Benjamin Drummond. And I think there's some more information in your programs on the history. This evening's discussion looks at the 14th Amendment, African Americans, and the meaning of citizenship. I want to give a special thanks in this first panel to our advisory committee, Dr. Jim Grossman, Executive Director of the American Historical Association, Dr. Edna Green Medford, former chair and professor, Department of History, Howard University, Dr. D. Derek Musgrove, associate professor, Department of History, University of Maryland, Baltimore County, Dr. Sharita Jacobs Thompson, an independent scholar and Hill Center's resident humanities specialist, and Marianne Brownlow, who has been instrumental in creating this wonderful series. And a fervent thank you to our sponsors, the Executive Office of the Mayor, DC Commission on the Arts and Humanities, the American Historical Association, the Association for the Study of African American Life and History, and not to be left out, Uber. Hence, the evaluation forms on your chairs. Please fill them out. We read them with intense interest, we record them, and we report them. So please, at the end of the discussion, take a moment to fill those out and turn them in outside. But this evening, please take a moment to turn off your mobile devices. Please welcome our esteemed panelists, Dean Danielle Holly Walker, the Dean and Professor of Law at Howard University School of Law, and Professor Garrett Epps, Professor of Law at the University of Baltimore, and the Supreme Court correspondent for The Atlantic Online. Our panelists are in the capable hands of moderator Anas, I did not know that was your first name, Andy Shalal, an Iraqi-American activist, artist, and social entrepreneur. As most people I'm sure know, he's the founder of Busboys and Poets, an Eatonville restaurant. And I love this description of these spaces. Both restaurant concepts create an environment where racial and cultural connections are consciously or perhaps intentionally uplifted. Spaces to feed the mind, body, and soul, and where art, culture, and politics take center stage. And as we all remember, he was a 2013 candidate for mayor of Washington, D.C. The format will be a conversation followed by a very brief Q&A at the end. We'll have a microphone to pass around. But perhaps of more interest, Professor Epps's book, Democracy Reborn, the 14th Amendment and the Fight for Equal Rights in Post-War America, is available for sale by our wonderful neighbors, East City Books, and you can purchase a copy afterwards, and Professor Epps has graciously agreed to autograph them.
It's great.
Right. Now,
No spoilers.
Yes. So now, I'm going to get out of the way of the conversation and turn it over to Mr. Shalom.
Well, thank you so much. I'm going to try to get out of the way as well. I am not a constitutional scholar. I will leave it in the able hands of the folks that are here. I have to say, when I read the title of the event, it made me wince a little bit, and I'm not sure why, but maybe we'll talk a little bit more about that. But I am a naturalized citizen, so the whole idea of citizenship plays a big part in my life, and certainly plays a part in this amendment as well. I want to turn to you first, Danielle. Maybe you can set the stage for us. I know it dealt with the Dred Scott decision, obviously Dred Scott versus Sanford. Can you tell us a little bit about that case? Set the stage for us here.
So in running up to the 14th Amendment, we wanted to set the stage a little bit by talking about the infamous case of Dred Scott versus Sanford. How many of you have heard of Dred Scott? Good. So this is not new to this audience, 1857 Supreme Court case. And it was really, I tell people, I teach this case all the time in the first year of law school in a course called Civil Procedure. And people don't typically think of it as a procedural case, but that's exactly what it was. So one of the grounds for being in federal court is that one citizen of one state can sue a citizen from another state. And Dred Scott was claiming that he had the ability to basically bring a tort action in federal court, which would mean he would need to be a citizen of Missouri in order to do that. So that's really the question of the case. Is Dred Scott a citizen of a state? Is he a citizen that is able to bring a case against a citizen of another state, in this case Sanford, who was his owner? And this is really a story about family, right? So it wasn't just about Dred Scott, but also his wife and his two daughters, who were also held in bondage. And so the court's opinion that has really, a lot of the language has unfortunately lived with us and lived on by Justice Taney, talks about what it means to really be a member of the political community, right? So does someone of African descent, and it's interesting that in some ways we can think of this as the case that really said that people of African descent can never be what we now call African Americans, right? So Taney's point was really that if you are of African descent, you can never be an American. I wanted to, read a portion of the case just because the language, I think, animates so much of how we still think about this case, and especially the way Justice Taney, I think, frames the issue in the case. So he says, the question is simply this: can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community, formed and brought into existence by the Constitution of the United States, and as such, become entitled to all the rights and privileges and immunities guaranteed by that instrument to the citizen, one of which is the privilege of suing in a court of the United States in the cases specified in the Constitution, right? So he really asked the central question the court does: can Scott, can his family, can they really be part of the American project? Can they be part of the American political community? And of course, in this case, they say that the answer is no, that there is not a way for people of African descent to be part of the political community. And one of the things that Taney does is he traces back to the history of the Declaration of Independence and asks, what was the atmosphere in the country at the time of the drafting of the Constitution? And he says at the time of the drafting of the Constitution, there was no thinking that people of African descent could ever be members of the political community or citizens of any state or citizens of the United States. In one of the most famous passages of the opinion, he says, they had, talking about people of African descent, for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. He was bought and sold and treated as an ordinary article of merchandise in traffic whenever a profit could be made by it. So this kind of definitive statement that in the history of the United States, there had never been any rights or privileges that people of African descent had that anyone who was white was really bound to respect. So this notion of really tying together race with political community, this idea of belonging, and also this notion that just having this badge of race could completely exclude you from that community. And so that really sets the stage for how dramatic it is to then have the 14th Amendment, because remember, this is 1857. So the time period between this and the adoption of the 14th Amendment is not very long, only 2 decades really between those two. And to go from the kind of definitive statements made in Dred Scott to the adoption of the 14th Amendment is something that is important to keep in mind as we begin to talk about the 14th Amendment and why it so radically kind of altered this notion of what it means to be a citizen.
And I'm amazed at how relatively recent this history is. I mean, when you think about it, it's like 2 75-year-olds back to back, you know, and then you've got you're back there, and it's quite remarkable to hear the language and see how things have changed in some ways and other ways haven't. I want to turn to you, Garrett, and you've written a book on the 14th Amendment, so you can really tell us a lot about what the 14th Amendment is all about, and particularly when it comes to the meaning of citizenship.
Well, I think the thing to understand about the 14th Amendment is that it is very much, as you say, involved with Dred Scott, but that it embodies, it's common, I think, in law textbooks, it's common for people to say it was the Citizenship Clause, which is the first clause of the 14th Amendment, is there to reverse Dred Scott. And it's purely in a descriptive sense, that's obviously true. But the fact of the matter is that the framers of the 14th Amendment, the people that adopted it and put it together, believed profoundly and had since before the Civil War that Dred Scott, you know, was a lawless decision, that it had, and Chief Justice Taney, and by the way, as a professor at the University of Baltimore, I'd like to invite everybody to come to Baltimore and not see the damn statue of Taney because it's gone. Finally, thank God. But he had adopted the most extreme version possible of the relationship, political relationship between people of African descent and the United States that you know was just greeted with, you know, almost would have been ridicule, except that the consequences were so tragic. And so the Citizenship Clause of the 14th Amendment, which is the centerpiece of Section 1 of the 14th Amendment, I think by its authors was regarded not as changing the law, not as making people of African descent citizens who hadn't previously been, but as declaratory, what Senator Ben Wade said, this section, he introduced it, this section, as I see it, declares what the law has always been, that all people born in the United States, regardless of their race, were citizens of the United States, always had been, that the structures that were erected by states to deny them the privileges of citizenships were illegitimate and unlawful. So this becomes a subject that is debated constantly. As early as 1870, a man named Hiram Revels was elected to the United States Senate from Mississippi, the first man of African descent to sit as a senator. And the Democrats tried to block his admission to the Senate by saying, oh, you have to be a citizen for 9 years to be a senator. And he's only been a senator since 1868 when the 14th Amendment was adopted. And the Senate said, you know, basically what I tell my students is sometimes that decisions are, homie, don't play that. And that was this one. The Senate just said, no, this was declaratory. Revels always was a citizen. And that idea of citizenship as central to the very existence of our political community in the sense of making it democratic, I think is really the most important single thing about the 14th Amendment, and everything else radiates out from that.
And you know, to bring it again back to how history isn't so far, we have President Obama, who was elected. there were a lot of people that were speaking about his citizenship and
Yes.
the birthers and so on. So this has carried on, obviously.
Well, in constitutional law, nothing ever dies.
Right.
It just takes to the hills, right?
Right.
I lived for 16 years in the Pacific Northwest, and when you teach constitutional law in that part of the world, you meet a lot of people with titles like Minister of Defense of the Sovereign Republic of Jefferson and so forth, and they have a concept which they were very wedded to, that there was such a thing as a sovereign citizen. A sovereign citizen of the United States is a white male who has all the privileges of citizenships, and that everyone else is, they call a 14th Amendment citizen. Right? And that means people of color, it means women, it means naturalized citizens, and they have lesser rights, right? So this notion that the United States community is at its heart racial, and that everything else exists really just sort of by the sufferance of the white man. It's very, very powerful. It goes back to the creation, and we're dealing with it now in more ways than are comfortable to think about.
Yeah, it's so interesting. The first time I ever heard, kind of someone state kind of the birther claim, and I said, this is essentially the argument from Dred Scott, right? So it's that it isn't possible, really, for someone of Obama's hue, of his background, to be a true citizen, but also to be the legitimate leader of the United States, right? So that there's no possible way that that would be true. And I think when we think about citizenship, it's interesting how every time it shouldn't seem so relevant, right? So 150 plus years later, it shouldn't seem so relevant, the wording of Dred Scott, but it brought up so many thoughts, including this birther conversation, because I think so much of the question of citizenship is about the rights that flow from citizenship.
Yes, absolutely.
And so what does it mean if you aren't truly recognized in the political community to fight for things like the right to vote? So when we think of what happened in the aftermath of the 14th Amendment, it doesn't seem like much to grant people or to recognize what you say was their inherent citizenship and then to subject them to Jim Crow, right? So how can you have a citizenship clause that says we're recognizing your inherent kind of participation, existence in the political community, and then take away all of your political and civil rights almost immediately thereafter? So I think the questions have never been settled, right? So this question of who is the essential American? Who is the real American? Who embodies, when you think of America, who's the first person that pops into your mind? And then what does that have to do with the rights and privileges that that person enjoys? And then does that person get to decide what rights and privileges everyone else who doesn't encapsulate that kind of quintessential American, whoever you think that is? What does it mean about the rest of us who are then left to be handed out rights?
Since we have two lawyers here, I can get some free advice here. So for me,
don't sign anything.
Don't sign
anything. Read everything first.
As a naturalized citizen, can my citizenship be revoked?
The answer to that
Am I a 14th Amendment citizen?
The answer to that is yes.
Yes.
It can be revoked if you are found to have made a material misstatement in your citizenship application. So the most obvious cases we've all heard about are the person who was actually a prison concentration camp guard, but who denied that having done that. And those
or a member of the Communist Party or something, and they denied, because that was actually one of the questions I asked you on. Is that have you ever been a member of the Communist Party?
And they still ask that.
I think I was
yes.
What, 1983 is when I became a citizen.
Well, I
have no idea what I answered. I don't remember.
I actually knew someone, of the father of one of my students, who came from the Soviet Union and had been a member of the Communist Party, and he checked yes, and the INS agent looked at it and said, "No, you're supposed to check no."
Yeah, right. That's right.
And he said, "Well, no, I really was one."
I really was, yeah.
And he said, "I'm going to have to call Washington." And after a while, he came back and said, "It's okay." But,
But it's
But,
interesting
yeah.
that there have been birthright citizenship bills introduced.
Yeah.
So very recently,
for
over
the
the
dreamers,
last
or
decade,
I mean, not the dreamers, but
To cut
the
back.
there are
the
proposals
immigrants,
right
yeah,
now
for the immigrants that
to-
have been born
yes.
Yeah.
to foreign nationals,
Right.
and even though by right they can become citizens as by their birthright, some people are trying to take that away.
And
That's
to
right.
argue that you would need to demonstrate that you have either one or two parents who were born here in the United States to be able to claim citizenship at birth instead of what we think of now as birthright citizenship.
It is really just the most sort of transparent racialization of
Yes.
citizenship, even though it is put in terms of allegiance. And I've been debating people about this for 10 years, and there's a great deal of quoting from Emmerich de Vattel and so forth. It's basically what was going on in Dred Scott, because if you really push down on what Chief Justice Taney was saying in that opinion, he was saying, look, I know what it says in the Declaration of Independence, but come on, you don't think they were really serious about that, right? Like Joe Pesci in My Cousin Vinny, you were serious about that. Everybody knows they didn't mean anybody but whites. We all know that. Come on, let's quit playing around, right? That is the logic behind Dred Scott. And that is the logic that is being deployed now.
And that's the part I think that when I mentioned earlier, the
Yeah.
title made me wince a little bit, that hyphenated titles. I'm always concerned about hyphenated titles because you're right. When you think of American, you think what comes to your head, right? There's no hyphen. And I think sometimes when we use hyphens, it makes you a 14th Amendment citizen as opposed to a
It's interesting because I
full
always
citizen.
think the people who were most tied to this notion that to be American, you must be white, right? Those people, I think, would be most disturbed by this notion that we have the hyphens, right? That you can be both American and you can be African,
Right.
that you can be both Asian and you can be American. I think in some ways the hyphenates, even though I don't tend to use the hyphenate very much, I tend to say people of African descent or Black Americans, but I think that the hyphen in itself is a recognition of the 14th Amendment, right? So it's a recognition that regardless of your racial, ethnic background, that we can all claim the mantle of American. And I think that that is something very powerful that the 14th Amendment has given us. Again, it's complicated by the notion that even when the 14th Amendment says, okay, by birthright or naturalization, you are a citizen, the question is, what does that word really mean when you have groups of people that are denied rights for 100 years, the most basic political and civil rights after the adoption of the 14th Amendment? So in that way, you can say that the concept of citizenship in the 14th Amendment was not a very robust one because it didn't protect, right? So it didn't protect people of African descent in the first 100 years of its existence. And a lot of people would argue, I think including myself, it doesn't offer, we think of now the most kind of compelling challenges to marginalized communities in this country right now, whether it be over-policing, whether it be lack of quality education, voting rights. How much protection is this notion of citizenship really offering to the most marginalized in our society?
Did you want to say something?
Go ahead.
No, I wanted to ask about the atmosphere at the time that pushed this amendment forward. Obviously, they had to have a lot of people in favor of it in order for it to pass. What was that atmosphere like? I know Buchanan was about to be elected.
You're talking about Dred Scott.
I'm talking about Dred Scott.
Yeah,
yes.
yeah.
Back then, and I'm trying to figure out what was the climate like back then, and what happened that changed it in a sense?
I think obviously the tension that eventually sprang forth into the Civil War is exactly the atmosphere of the time. And I think what Professor Epps was saying is exactly right. This notion of the people in the North who really were disturbed and becoming to the point where they were done with the slave power, right?
Yeah.
So this notion that the slave power was really controlling the instruments of government, including the Supreme Court, that's what Dred Scott really began to stand for, is that even if there are a majority of people in this country who no longer agree with slavery, don't think we should move forward in this way, and want to see recognition of people of African descent, or want to see the abolition of slavery, they felt very pushed around, right? And that they had really lost control of what they felt like should have been their political point of view. And so the Supreme Court, and I think that's sometimes why Supreme Court decisions can be so antagonizing for democracy, right? Is that here they saw it as an anti-democratic, what they felt like was the majority opinion of much of the country at the time, and one that really left no choice, right? So when your political options are off the table, the Supreme Court has declared that people of African descent are not citizens. What choice was there but war? Right.
Well, and the other thing, of course, is that they were waiting for Dred Scott 2. This is how they called it. Because what Dred Scott 1 had said was that Congress could not outlaw slavery in the territories, okay? Because the Fifth Amendment protected property, and people had a right to their property, their human property. The next step, and the logic, it would have made perfect sense, would be to say no state can do that either, which would have meant the end of free states. And Lincoln, in one of his speeches, I think it's Cooper Union, but it may have been during the Lincoln-Douglas debates, he said, we shall lie down pleasantly dreaming that America will become a free nation, and wake up to find that Illinois is a slave state. And that is what they thought was coming. And just as a hypothetical, I mean, just to interject, people I grew up in Richmond, and I was always told that the wall between the states was about states' rights, and then I would say, well, yeah, it was about states' rights to have slavery, and then they would explain, shut up, They said that I would say it's about states' rights to have slavery, and my teachers would explain
the reason for the Civil War.
That I should shut up. Yeah, but honestly, that the North were the states' rights advocates during that period around Dred Scott and afterwards, because they were the ones who saw, and really you can't understand the 14th Amendment without understanding this notion of the slave power. Right. They saw a constitutional malformation that gave undue power to states that allowed slavery, and they saw it gradually taking over the federal establishment completely, with the intent, of doing certain things that the South had openly talked about. We're going to reopen the international slave trade, which has been illegal since 1808, because we have a right to bring in as many slaves as we want. We're going to annex Cuba and use that as a source for slaves, because we're going to take away, there are not going to be any free states. We're going to extend slavery throughout all the territories in the new states, because slavery is a positive good. And this slave power, which is the term that was used, is the background to the 14th Amendment. If you read the whole 14th Amendment, you will see that they begin by taking on Dred Scott and just move through all the aspects by which they saw slave states as exercising undue influence in the Electoral College, in Congress, in economics, and so forth. That's really what the 14th Amendment is about, is, we are going to be a republic, a free republic, and we are not going to reward these undemocratic states that have slavery or that oppress large numbers of their population.
So we're talking about the citizenship clause, but there are other clauses, of course, that are very significant in the 14th Amendment. Can you speak a little bit about them as well?
Well, yeah, sure. If you look at the citizenship clause as kind of the kind of opening note, right, that draws it all together. And one of the interesting things about what we've been talking about is that, there is this thing of, like, if you tell people don't think about an elephant, they immediately think about an elephant, right? So the 14th Amendment opens with this incredibly expansive statement that there is one citizenship in this country that extends to all people. All persons, born or naturalized, doesn't matter, born or naturalized, in the United States and subject to the jurisdiction thereof, are, not shall be or should be, but are citizens of the United States and of the state wherein they reside, so that it lays out this extremely sweeping, uniform, national definition of citizenship and explicitly says states cannot mess with that. Then it goes on in the next section and says, no state shall make or enforce any law that shall abridge the privileges or immunities of citizens of the United States. And that refers, the sponsor said at the time, that refers to what they called the Bill of Rights, which was then called the first 8 amendments to the Constitution, that these were rights that carried along as citizenship. And then the next part of Section 1 says, no, or that shall deny to persons within their jurisdiction the due process or equal protection. And that the use of the word persons was extremely advised. The sponsor of the 14th, one of the sponsors of the amendment in the House, John Bingham, said, it is the command of God, thou shalt not have one law for the child of the house and one law for the stranger at the gates. We must treat aliens, people who are not citizens, exactly as we treat our fellow citizens, with the exception of political rights like voting and being on juries. So you can see this structure of a democratic social order being set out in a very, everybody's a citizen, right? B, there are rights that nobody can take away from you. And C, even people who are not from here have to be treated fairly. That's just Section 1. So you're moving along, and Section 2, and I'm sure you, as we look at all the Reconstruction amendments, you realize how important this is. Section 2 is the first time that first of all, Section 1 is the first time that the Constitution uses the term equal in reference to human beings. Every other reference prior to that had been about states being equal, right? Section 2 is the first time the Constitution talks about the right to vote of citizens of the United States. Suddenly, it's a national right. It's the first, and it spreads on through that to talk about who can hold office. The federal government can't spend money to compensate people for the loss of slaves. And finally, it says Congress, right, will have the power, which hitherto it has lacked, to enforce the Bill of Rights against the states. So it sort of, it's like the Big Bang. You start with the citizenship clause, and it gradually just spills out to create this whole constitutional universe.
So I know we're here in Washington, D.C., and we have Emancipation Days coming up in a couple of days on the 16th of April. How does this amendment apply to the fact that D.C. has no voting rights, that we don't have equal protection?
I mean, I think that the 14th Amendment should be applied to say that citizens of DC should, but some people, the argument is that citizens of the states,
it's been argued, I'm sure, but
so citizens of the states, right? So it refers to
that's
states,
the word that keeps us out,
right? Which is why we talk so much about DC statehood, right?
Exactly.
Of the several states or something like that.
Exactly.
That's
So when it says that the state should not be able to deny people due process or equal protection of the laws, then the question is, what happens when it's not
a state?
Yeah.
Exactly. So that's why the importance of DC statehood.
Talk about a
to
technicality.
this question, yes, to this question of whether we, as the citizens of the city, have a right to representation in Congress and a right to vote in a Senate or House election. And so that is the key, is the language that talks about states and the application, kind of enforcement of rights against the states, or the states not being allowed to abridge the rights of individuals and to treat people within the equal protection of the law. It doesn't apply, arguably, to those of us who are not considered to be the citizen of a state.
That's true. And one of the really interesting pieces of history of the past 60 years is that when the cases that we call Brown versus Board, which were multiple challenges to school segregation, reached the court, there was, eventually at least a majority, it ended up being unanimous, to hold that states maintaining school segregation was a violation of the Equal Protection Clause of the 14th Amendment. One of the cases that was in front of the court was called Bowling versus Sharp.
Right.
And that was a challenge to the District of Columbia's operating a full-fledged Old South dual school system within the district. Mm-hmm. And so somebody said, well, what do we do about this? Because the Equal Protection Clause applies only against states. And, I always tell my students that this whole thing was kind of resolved the way, there's fancier language, but it's really resolved the way that you resolve problems, particularly if you're a parent, you're used to this logic, which is at a certain point somebody presents you with a theory, and the theory is that the states can't have segregation, but the federal government can. And someone said, oh, for God's sake, that's the stupidest thing I've ever heard. We're not doing that. And basically, that's what Bowling versus Sharp says. It's, well, it's not in the Constitution, but it wouldn't make any sense at all. So, of course, that principle could carry over, but it is up against the textual provision that gives Congress the power to legislate in all cases whatsoever for that district not to exceed 10 miles square, which shall be designated as the national capital. So that kind of takes the district out of, I think they thought no one would ever actually live here full time. It's a swampland.
It's odd that would make sense. In some way they sort of justified it. I mean, it's funny. I'm a citizen of the United States, a naturalized citizen. Who doesn't remember whether they belong to the Communist Party or not at this point, but I'll have to go back and check just to make sure. But I as a person who is a citizen of this country, I cannot vote for a representative here in Washington, D.C., but I can vote, according to the United States, when they invaded Iraq. I was able to vote in the Iraqi parliament.
Mm.
I haven't been to Iraq in 50 years.
Well, one of the great ironies.
Before my daughter, who was born in this country, doesn't know a thing about Iraq other than the fact that her dad comes from there, can vote at the parliament for Iraq, but cannot vote in this country.
But one thing you'll note since 1945 is that every time the U.S. goes to war with a country and ends up occupying it, we have this constitution that appears that has a much more robust set of rights than we have.
Than the ones that we have.
Right. So the Constitution of Japan, Afghanistan, Iraq, all of these places, it says, oh, the right to vote shall be universal and everyone shall have it. But what about at home? Not so much.
Not so much.
Not so much.
Slow down.
Right. Go vote in Iraq. Don't bother us.
And having moved here just 4 years ago, I mean, the strange nature of going to vote, and I was like, this ballot is incredibly short.
The lines, right?
Yes, and I was like, where are all? And of
course,
except
in 2008,
right?
The lines are really long.
Yeah, so I just moved here in 2014, and I think I felt that loss of citizenship more than I thought I would, and that is something that I did not expect. To feel that loss of having, two senators that I can call. I've, in all the political turmoil that we've had in the last 16 months, I find myself calling my senators from South Carolina because I own a house in South Carolina. So I call senators from South Carolina. I'll even call senators from Texas saying, well, my parents live in Texas. So, I can, and I was raised in Texas, so I can call them too. But just the idea that representation is so limited for the people of this city, and considering also the population of this city in comparison to many states in the United States, to think
a lot bigger than Wyoming.
Yes, to think that this city is left without representation, I think is something that we should take very seriously, not just in the week of emancipation day, but just all year round, to really push for DC statehood. I think is incredibly important.
What other applications of the 14th Amendment do we have in the political climate that we have here in this country today, vis-a-vis the Dreamers, all of those issues that are coming up that deal with citizenship, that deal with rights, that deal with equal protection, all of those things?
Well, it goes from sort of fairly mundane but important ones to the ones that are really go to the very heart of what kind of country this is. But right now, ICE can grab people off the street and hustle them into immigration detention and try to persuade them to take expedited voluntary departure. If they can try that. Mm-hmm. But if people are prepared to insist, the fact that they are aliens, the fact that they are not documented, does not mean that they don't have due process rights.
Exactly.
And that's important against states.
That's the immigration enforcement organization. Yeah.
But it's also important in states. Mm-hmm. States, there have been repeated attempts over the past 15 years to come up with sets of laws that would basically, state laws that would treat the undocumented so harshly that they could drive them out of the state. And the answer is, there are limits on your ability to do that because the 14th Amendment says all persons are entitled to equal protection. All persons are entitled to due process. So that's something we almost take for granted.
All persons, regardless of their citizenship.
So when we think of a case like Plyler versus Doe, which is where we get the Dreamers from. So the idea of whether people who are undocumented, who are not citizens of this country, can go to public school. And so the Supreme Court said, yes, they do have the right to equal protection under the 14th Amendment, and therefore can take advantage of, if there is a notion that you should have universal schooling, which most states have, this notion that you have actually a compulsory school attendance, that those laws apply to persons in the state and not just people who can prove citizenship.
Mm.
And I think the Plyler precedent, which is very important, is under attack. It's under attack constantly. There are people who are quite hostile to it and who would like to come up with a situation in which undocumented persons cannot, their children can never become citizens. Does this sound familiar?
Right.
Can never become citizens and would not have equal protection rights to access things like schools, medical care, and so forth. In essence, this is my view as someone who grew up in the South and grappled a lot with the heritage of slavery. In essence, this is a proposal to reinvent slavery, to create a caste, hereditary, hierarchical, lifelong caste system in which some people will have no rights that real citizens are bound to respect. And we are in a world of hurt if we get there. It is so completely contrary to what the 14th Amendment and the Civil War settlement are really all about that we should be watching very carefully as this dialogue progresses.
And just recently, I can't remember what state it was, just a few days ago, announced that they're proposing legislation in which people who are undocumented actually have a mark on their license.
Oh.
That says that they are not citizens. And so just the thought of what that would be used for when licenses are, produced for law enforcement, et cetera, but to have that kind of mark, I think we are kind of going back to a place where just the notion of what persons, regardless of their citizenship, are entitled to in terms of their rights in this country is very much under attack. And again, the legislative proposals, when people talk about quote, immigration reform, we have to remember that some of those proposals have been to go to a system of recognizing citizenship only for people whose parents were citizens in this country. That is very much on the table. So if people don't think that's part of the discussion, there is a wide-ranging discussion about what will be the new regime for immigration in this country. And I think it could go either way. I mean, I think we are in a position right now where I think some of the attack that we're seeing definitely on Dreamers. So these are people who were brought here as children, obviously, and had no, say in whether they were brought here, and are really, when, again, bringing back the language of Dred Scott, are they members of the political community? So when you ask yourself, okay, if someone's brought here when they're 2 or when they're 5, and they're now a young adult, they're 20, they're 21, do we see those Dreamers as members of the political community? And I think we are hearing a very wide range of answer to that question that to me would seem like a pretty straightforward answer. But again, it goes back to, can they ever be, even though we know that they've lived here, many of them for their entire lives have no connection to their country of birth, can they ever really be a part of the fabric of this community? And so that language, so we hear back and forth about these, these students, these young people are really, they're your teachers. So hearing the stories about a special ed teacher who's a dreamer, and how many teachers are dreamers? I was surprised to hear that. And then the question is still asked, but do they belong? Should they be here, even though we know they're taking on some of the toughest jobs here in the United States, are doing everything they can to be members of the community, have served in the military.
I mean, even more egregious. I wanted to ask you maybe a little bit of a deeper question, because I think most Americans believe that our system has enough checks and balances, that we have a constitution that's very powerful and very strong, and therefore some of these things are unlikely to happen, or so out there that nobody wants to really believe that there's even a possibility of things like that happening. What checks and balances do we have to ensure that these hard-fought amendments and hard-fought rights that have been earned over the years aren't going to be eroded?
Oh gosh, which one of us is going to be? I think we have nothing
than
the voices.
All right, it's over.
Other than the voices of the citizens. I really believe that. I don't think we can look at the history, especially the history of Jim Crow. It would be different if we hadn't lived under a 100-year regime after the passage of the 14th Amendment that completely denied the political and civil rights of people of African descent. If that had never happened, I'd be more optimistic. But the fact that we did, and that the only thing that reversed it was not, remember, it was the voices of the people. You could say with the little kickstart from the Supreme Court in Brown versus Board of Education. But when I look at what's happening right now, I don't think that anyone should think that we cannot go back to a place where many of the things that we thought were recognized as basic political and civil rights connected to the Civil Rights Amendment, connected to the Civil War Amendments, could not go away or be significantly eroded. I think part of what the activists of Black Lives Matter are saying is that the basic kind of right to be free of violence from the government, right? To be free of violence from the government. If you were in your own backyard using a cell phone and the government comes into your backyard and shoots and kills you and you're unarmed, what in the Constitution is standing between that citizen in his backyard and the government?
And it certainly isn't courts.
You're supposed to answer that. So what's
nothing?
Nothing.
Well, it's certainly not. It's not courts. I mean, history shows courts follow; they don't lead. We can't look to our court system to sort of say, liberty is great and we're going to protect it for everybody. The thing that can save us if we are saved is the vote and mass mobilization and people saying, by God, I want to live in a democracy. I don't want to live in an authoritarian, racialized, blood and soil, post-democratic republic. I won't have it. I won't have it for me. I won't have it for my children. And if enough people do that and enough people insist on their right to vote and on being heard, then we have a chance to survive. But there is no other check or balance that will do it without that.
And I do believe, and I want to back up and say, obviously as a law professor and as a lawyer, I do believe that the law is incredibly important. I do think we have seen tremendous progress in this country. Most of it has come from ordinary citizens raising their voices, and the voices get so loud to the point where our representatives in the courts must listen to us for our own protection. So that part, I absolutely, when you see what's happened with same-sex marriage, when you see the sea change in opinion about the death penalty, when you see what the attorneys of Brown versus Board of Education did, obviously this country has seen tremendous progress since the time of the writing of the Constitution, since the time of the drafting of the 14th Amendment. But I think if you become complacent and you believe that just inherently the Constitution, the words on the paper will protect you, I think we are seeing, and the story of this country is one that words on paper will not protect you. It's only the citizens really demanding that their rights be respected. That is the only way that we are protected. And you can do that as a citizen through, or just as a person who is here and cares about this country. And some of us are trained to do it in other formats in courts of law, et cetera. But that in itself, just this notion that we have a constitution and it has lots of wonderful words on it, that doesn't protect anyone on a day-to-day basis. It is something that we as citizens and we as people who care about the words on that page have to continuously fight for.
Do you think the average American knows what democracy is? I mean, I'm asking
I'm not
that.
sure I do.
And
Gosh.
I'm asking that because I think you mentioned something earlier, Danielle, about the idea of that you realize you lost your vote by moving to DC. You have an Emancipation Day, gathering, and you end up with 100 people, maybe a couple hundred people show up demanding the vote. A lot of times when you're in it, you don't really, think about it too much, and you don't really care in a sense. I always say I'm actually a real citizen because I became a citizen by choice. Some of you here are born in this country. You're a real citizen, right? But I became a citizen by choice, which means I actually read the Constitution. I had to actually take a test to be able to pass it, and so on. I would venture to guess most Americans have not read the Constitution. Would you agree with that?
Yeah.
So I think with that in mind, what hope do we have for the average citizen to be engaged to the level that you're talking about? Because this is deeper than just showing up and voting once every 4 years.
I think the past few weeks when I saw the students of Parkland and the other students, including students from this city, from Thurgood Marshall Academy, who stood at the mall and talked about what they feel is their right to life and to be protected as they go to school from losing their lives to gun violence. What I thought is most of those students probably, they may have had to read the Constitution, maybe for US government, maybe for government AP, but they were articulating the values of our democracy in a way that if they haven't read it, they definitely were articulating what, and probably because many of our rights that are embodied in the Constitution flow from natural law or what we would think of our God-given or creator-given rights, and they were articulating them. So in that way, I do feel like most Americans do have a sense of right and wrong, right? Whether they know that it's embodied in the Constitution or not, but those essential ideas of life, liberty, in the pursuit of happiness that are actually not in the Constitution and the Declaration, but this notion of what is really core to our values, at least that was, and as I saw people, I mean, and this is true, and I'll say this is not political in the sense that even though I don't agree with all of it, I mean, I think that the people who were out protesting during the Tea Party movement, I deeply disagree with them and their view of the Constitution and their view of life in America. But do I think that they believe that they were articulating values that even though they couldn't tie them to certain parts of the Constitution, they were articulating what they felt were the rights that they felt should be protected. Most of them, if they had pointed to provisions of the Constitution, they would have been able to find something there that they were then saying in the protest.
And I think that people may not be able to define democracy. They may not be able to say how it should be run, but people have a gut sense of how they want government to treat them. And the challenge is to get people to universalize that. And the big obstacle to that takes us back to Dred Scott, is the idea that there are kinds of people who are not really entitled to the same kind of treatment that I get. So that the most important thing we as citizens can do, the most important single thing, there's lots of other things, over and over and over, we have to say what started to be said at the time of Dred Scott, which was being said even before that, which is, no, this is not a racial blood and soil republic. This is not a white republic. This is not a Christian republic. This is a democratic republic, and all people have to be treated equally. And if they're not, no one's going to end up being treated well. To the extent that the ordinary American adopts that idea, that belief in fairness, that belief that everybody should be treated all right, the political outcomes will tend to take care of themselves. But to the extent that they are persuaded, and particularly by powerful voices in government, who signal in every conceivable way that there's a racial character to being a real American, that's incredibly dangerous.
And that to me would be an interesting poll question to ask.
Yeah.
I've never seen it phrased that way, but to ask, do you believe, to give people a list of rights and ask, do you believe that everyone who currently resides in the United States has this right?
Yeah.
Or that right? And I think that is one of the hardest things to universalize, because for most of us, we can think of all the rights that we would want to have preserved for ourselves, for our families, for our loved ones, for people who share our faith, for people who share our racial and ethnic background. We can think of all those things, but can you really look at someone else who's very different from you and say, I believe that they also enjoy those rights? For me, I'm an education scholar. I write a lot about education and civil rights. And when you look at the state of our schools and say, okay, everyone, regardless of race, is entitled to equal protection of the laws, but yet you can drive by schools in this country, and by looking at them on the outside, or if you take 1 foot inside, you can tell who goes to school there, how wealthy their parents are, their race. So that in itself is a demonstration that we have failed to universalize our concept of what it means to have equal protection of the law. And until we do that, I think that is something that I think is core to our democracy, that we've made progress, but we are not, nearly where we should be, in the sense that we have so many things in this country, like our schools, that you say, okay, this is so inconsistent with our constitutional ideals, but yet it exists and goes on. We have generations of students raised and really schooled in very unequal circumstances.
Mm-hmm. What other cases have been used in the 14th Amendment, that the 14th Amendment was used to be able to protect or defend? What other issues that we know of today?
Well, a good deal of the law that protects sex equality in this country slowly grew up out of the 14th Amendment, and it was quite clear at the time the Equal Protection Clause was adopted that it was going to be used in some ways to deal with relationships between the sexes. It took quite a long time for that to happen. In some ways, the most important single 14th Amendment decision for the workings of our society as a democracy was, in a case called Baker versus Carr, and its succeeding case, Reynolds versus Sims, in which the court said the Equal Protection Clause of the Constitution means that it is absolutely forbidden for states to do what they routinely would do until this happened in the 60s, which is to say, we think certain voters are smarter than other voters, and they should have more influence. So I grew up in Virginia, and it was very explicitly said, this was not no hide the ball. They said, we believe that the country folk, the good, honest yeomen, Mr. Jefferson's yeomen persons, are the repositories of wisdom and not the urban mob. And that was the term that was used. And so the districts would be drawn so that, just to take random numbers, 100,000 farmers would have a member of Congress, and 300,000 urbanites, many of whom were, African American, would have a member of Congress, and it was unequal. And the Supreme Court said that the Equal Protection Clause is really clear. They said, this isn't even complicated. Bring us a hard one. No, you can't do that, right? And that principle has been under attack almost since the day it was enunciated. It is the bedrock of our current democracy. Attorney General Sessions is mounting an attack on it by distorting the census and so forth. But that's a classic example of how things that we just take for granted, you know, that we would not be America without, come from the 14th Amendment and are still contested.
Mm. Very good. I want to open it up for a conversation with the audience here.
Just because we're Facebook Living this, if you have a question, is this on?
Yeah.
Probably on Facebook Live.
Did you know you're on Facebook?
Yes, I remember told us that, but I kind of forgot.
I want to say hi to Mr. Zuckerberg.
I'm
Appreciate
Stu
him
Zuckerman.
dropping
They call me
by.
Zuckerman
Yeah.
today. One of the
Zuckerman.
Thank you very much for a lot of historical aspects and where we are today. And I wanted to ask you from the perspective of what law was previously there, what we have and what we're using as law that was previously there, and a different time that we're in now. We were an isolation country. Charles Lindbergh wasn't flying around. We're in a totally different situation today. And it seems like we have a lot of loopholes that we can't seem to fix, where women from countries can come here on vacation to have to give birth to children that become automatic U.S. citizens. And that would be fine. I guess the question is, should we change something from a reciprocity situation where you go to a country and you have to pay for a visa because it's back and forth and it's mutual? Should people that can come to this country to give birth, should we have U.S. citizens be allowed to go to those countries and have equal rights, where something where we call undocumented immigrants, illegal immigrants, whatever the term is, if it's mutual, is that a fair way to fix things that people have concern with?
So you want to say you want to have the right to go to another country and give birth and become a citizen of
Whatever,
that country?
as an example, whatever it is, or I want to vote in Iraq, right? So yes, you can do that. Okay, well then you can vote in whatever the example would be, right? What are these things that people have? And there's millions of them, but how do we work through all the details of the micro aspect when we have a law that isn't so, it's not easy, it's not malleable?
How is this kind of amendment change over the time?
Well, let me tackle a couple of things.
Yeah.
There's a bunch of things in that question, very generative of debate. But one thing I want to start with is that we really need to look hard at, and that frequently I'm said is what they say, well, when the 14th Amendment was put in place, we didn't know about illegal aliens. We didn't know there would be this problem, the so-called anchor baby problem or whatever, because that was a different situation then. I always double check these figures before I make a public appearance because they're so hard for people to absorb. But I think it's important to understand that at the time the 14th Amendment was added to our Constitution, the percentage of immigrants, the percentage of foreign-born people living in the United States was higher than it is today. Immigration was a subject that the framers of the 14th Amendment understood extremely well. And they knew that they were dealing with the citizenship of immigrants and immigrant children when they adopted the Birthright Citizenship Clause. So for that reason, I think we would need to be very hesitant before we admit, remember the language, all persons born or naturalized in the United States. I think we have to be very careful before we begin picking, constitutional rights are like the sweater that your mom gave you, and then it gets a little hole in it, and you pick at it, and suddenly there's no sweater.
It unravels, right?
So, the idea that somehow we're going to start limiting citizenship because of actions of foreign governments, I think is kind of a category mistake. These are individual rights. These are human rights. The right of citizenship is not something we do to accommodate Iraq. It is something that the person who is born in our country has by virtue of being human. And so to think of it in terms of, well, our government doesn't want to give that government that, or this government, it's not about the government. It's about persons born or naturalized in the United States. And I would also, just quickly say, and the term didn't come up, but there is a term that is frequently used, anchor babies, which is, and I think if you think about the kind of diabolic use of language, where you take a baby, the most precious thing that you can possibly have. I mean, I know there are parents and grandparents in this room. A young American, a new member, someone bringing renewal to our country, and you call it an anchor, an object that is made out of lead and designed to be thrown into the mud and hold everybody down. Whoever thought of that was a genius, but it's horrible. That
Evil genius,
yes,
right?
and yeah, really, an evil genius.
So
And I
how
think
much of that sweater do we still have? Is that sweater still very intact?
We're doing okay.
We're doing
Got some
okay?
patches
There's a
on
few
the
holes in it?
elbows, yeah, but
Yeah.
I mean, it's always a danger.
And I would like to respond just to what I think, again, it's important not to take the kind of concept of birthright citizenship out of the concept of where it comes from, right? So we read what it was really, and even if we don't think of the 14th Amendment as a completely direct response to Dred Scott, what it was really there to do was to say that as a democracy, we do not think that it's helpful to this project. So not meaning what the rules are of citizenship in other countries, but in the American project, in the American democracy, that it's important not to have caste systems in the democracy, right? So this notion that the birthright citizenship was really a response to this notion that if you were of, in Dred Scott, that's, I wanted to add that they have to also tussle with what do we do about American Indians, right? So Tanny has to answer that question, because really what we had, and in many ways what we still have despite the 14th Amendment, is a racial caste system in this country. So birthright citizenship, when we say, yes, it may sound, you know, you take an extreme case like, okay, someone comes here, they have a baby here, they go right back to the country of origin, take the child with them, but now that child has citizenship rights. I would take that every day of the week, other than me having to check everyone's papers on the way as they go and say, so, you know, who is your mother? Who is your father? And it makes this a democratic project. As in as many places as I visit around the world and go other places, this is a unique, I do believe that the United States is a unique project that we are engaged in this democracy, one that requires, even though we've never quite lived up to it, this notion that we do not have a racial caste system. We don't have a religious caste system in this country. And in order to do that, birthright citizenship is a cornerstone of that project. To do it any other way, I believe, resets the table for saying, who is a real American, right? What birthright citizenship does is it says, if you were born in this country or if you're naturalized, we're all real Americans. There is no such thing as you touched down, your mom touched down here day one, you were born on day two, therefore you're not as real as I am, and my family's been here since the 17th century, right? We're all equally real Americans.
If I can add to that real quickly, and I know you'll know what I'm talking about, you talked about how recent all this is, right? But even more recent is to see how the idea of this hereditary caste system works, because it was operating well into my life until I was a teenager. The states of the Old South were maintaining these highly efficient, organized bureaucracies to track the racial makeup of every citizen within their borders. There's a wonderful book called Segregation Science that talks about the bureaucracy. There's a man named Dr. Walter Plecker, who became the Registrar of Vital Statistics of the Commonwealth of Virginia, who, among other things, thought from his scientific research that Native Americans were not really Indians, and so he just decided no one was allowed to be born as an Indian. And if you were, they would force hospitals to correct birth certificates. They would monitor people throughout their lives to make sure they didn't pass as anything other than their assigned race. And it is easier than we would like to think to kind of step back into that world. I think, as you say, if we have to err, probably better to err on the other side.
It's fascinating that you talk about the United States caste system. Again, when you're like in the water, you don't notice it, if you're a fish, right? So when we first came here, it was 1966. My family moved here. It was illegal for a black person and a white person
Yes.
to get married in
Yes.
Virginia.
Yeah, absolutely.
And it went on. I mean, this was like almost normal. And
Yeah.
for us, it was like we landed on Mars. It
Yeah,
just,
yeah.
it's so strange to have a country that has that kind of caste system,
Yeah.
at least in the experience that I come from. And yet there was a certain, I don't want to insult anyone or be offensive, but there was a certain sort of deference to it.
Yeah.
There was a certain acceptance of it in a strange way. This was a caste system that was set in place by some magical formula, and everybody kind of plays along. I want to talk a little bit, because it is Emancipation Day is coming up. I want to talk about the Emancipation Proclamation a little bit, if you don't mind. And the Emancipation Proclamation has always been troublesome to me. All right, so the idea of a proclamation that gives someone freedom by someone else seems almost strange. I mean, it is strange. It's not almost strange.
A little bit of a misnomer, because it really didn't free
Free
any slaves, right? So it was just a military order in which Lincoln basically said, if you are a person who's held in slavery in the occupied states, then you were able to, come work in the army, you're able to do it. But it wasn't anything that created citizenship.
No.
It didn't really free the slaves. It was just, in some ways, it was a wartime maneuver that allowed people who had been enslaved to come and join the Union Army, to leave where they were, because it disrupted the property system in the South by saying, okay, you no longer hold this property.
Well, and then it also created reparations for the slaveholders, didn't it?
No.
Where's some
It
of the
left
slave?
that open. It left that
But
open.
I thought here in D.C. weren't D.C.
Well, that was
slaveholders?
there was a
reparations?
compensated emancipation, but that's a different thing
Yeah,
than
that's
the Emancipation Proclamation. That was a local ordinance.
the one
got
that
passed.
was in
Yeah.
April of
Yeah.
1862.
Yeah, that's right.
Right.
So that's different from the proclamation. And,
Right.
the
But
pro-
this was a
Yeah.
I mean, it was a was it kind of a document to the Emancipation Proclamation?
I don't know how you assess that. I mean, Lincoln, it seems to me, based the proclamation largely on the war power.
Right.
On the power, there was this wonderful fiction that Ben Butler, General Ben Butler, came up with early in the war. I was brought up to call him the Beast, Ben the Beast Butler, but he actually turns out to have been a reasonably nice fellow. But he said, because slaves were running away and coming to Union lines and saying, I'm here to help you, right? And at first, General McClellan would escort them back to the plantations and say, ma'am, I believe your property is wanted off. And Butler is like, why are we doing that? Man, these people are running their plantations. They're powering their economy. They don't want to do it. And they said, well, legally, their property is the Fifth Amendment, all of this Dred Scott stuff. And he says, yeah, but, under the law of war, if people use property against that, that's contraband.
Interesting.
It's a contraband of war. So they began saying, well, here you are, your property, but you're contraband, so we're going to take you. And in a weird way, they became property of the army. And that became a term for runaway slaves. Oh, it looks like some contraband.
Contraband, yeah.
So the whole thing is based on the war power. And the problem with that is that when you confiscate property for the purpose of the war, at the end of the war, you have to give it back.
Yeah.
You have to give it back.
Yeah.
Right? That is clear. And Lincoln was really worried about that. And that's why he was so committed to the 13th Amendment.
What country gives back stuff after a war?
Happens all the time.
They don't do it to the Middle East. Every time they come into war in the Middle East, they keep it. I don't know what happens. But, the oil becomes theirs.
They
Right?
may not follow the law of war, but that's the law of war. And so, we end up with the 13th Amendment, and people don't read the 13th Amendment as much as they might. The wording of the 13th Amendment, if you really sit with it for a while, it'll blow your mind. It is the most radical provision, single provision in the U.S. Constitution. It's the precise opposite of the Emancipation Proclamation. So slavery or involuntary servitude, save as a punishment for crime of which the person shall have been duly convicted, shall not exist. It doesn't say the government shall not.
What year did the 13th Amendment?
It became part of the Constitution in December 1865.
65.
Yeah, just as the 39th Congress was reassembling. And it is the only Constitution that creates a private right that you can assert against another private citizen, not the government, but, you know, if you are thinking about keeping me as a slave, don't do it, because I can, you know, I can proceed against you for violating the Constitution. Slavery does not exist. And so, you know, it's almost, they said, yeah, we see this problem with the Emancipation Proclamation. We get through with this 13th Amendment. It's not going to be a problem anymore. It shall not exist anywhere subject to the jurisdiction. Anywhere the flag flies, no slavery.
Is there any mention of reparations at all?
The 14th Amendment says there will be no reparations.
Ah.
That is explicitly forbidden by the 14th Amendment. Because the South had made clear that they thought they were going to come back and take over Congress again, and they were going to do one of two things, if not both. One was repudiate the Union war debt, just default. Say, you know, one of there's a journalist who went to the South who says, you know, he's talking to a Southerner, and the Southerner says, y'all think we're going to pay taxes to pay for the expenses of y'all whipping us? It ain't going to happen. We're going to repudiate that debt. And the other thing was they were going to present a bill for compensation for the slave property that they had lost.
So that's where that came in.
Yes.
So what would be the argument in favor that is a legal argument?
Well, the Fifth Amendment says government can't take private property except with just compensation.
And so they would say, I think the reparations argument is that for years you took wages.
I didn't say it was a good argument.
Right.
Yeah.
But that would be the argument.
Right.
Yeah.
Interesting.
Yeah.
Okay. Next question, please.
Okay, I think let's have time for one more question.
One more question, okay.
Okay, I have a couple. Okay, so as a native Washingtonian, I wanted to just press a little bit more on the significance of the 14th Amendment, or I guess non-significance of the 14th Amendment to citizens of Washington, D.C., and why then, so my understanding is Bowling v. Sharp was decided on the basis of the due process clause of the Fifth Amendment, and then Heard v. Hodge, which was our companion case to Shelley v. Kramer, which made racially restricted deed covenants unenforceable by the courts, was decided on the basis of the Civil Rights Act of 1866. And I also just recently read that a case called Jones v. Mayer, which was ruled on by the Supreme Court right around the time of the Voting Right, or the Fair Housing Act, actually went further than the Fair Housing Act because it was also ruled on the basis of the Civil Rights Act of 1866. So why then did we need the 14th Amendment, I guess?
Because really the difference between the Constitution versus statutes, right? So the Constitution acts as the highest body of law, the ultimate law that protects you. Then statutes are easily overturned. So if I come along and say, okay, there's a Civil Rights Act of 1866, the next Congress could repeal the Civil Rights Act of 1866. So the constitutional protections are there as kind of the backstop is the ultimate protections, whereas your statutory rights may be taken away, maybe changed from year to year, whereas it takes a considerable amount more to change the Constitution and to change your constitutional rights. So that's why the 14th Amendment, that's why when people say we don't have any voting rights except for those that are protected by the Voting Rights Act of 1965, you can say, well, no, there are voting rights that are there under the Constitution. Now, they may not have been very well protected just by the constitutional provision, but all of those, so the Civil Rights Acts that you're talking about, all of those things are thought to, first of all, Congress has to have the power from the Constitution to be able to pass every statute that is on the book. So there is some need for a constitutional provision that would allow for the passage of a statute like the Civil Rights Act of 1866, the Civil Rights Act of 1964, the Voting Rights Act of 1965. All of those things are, you need a constitutional foundation to basically have a statutory protection in place.
And I would quickly add that, and I'd have to double check this, but I'm virtually certain it's correct, that Jones versus Alfred H. Meyer is not solely based on the Civil Rights Act. It also flows out of the 13th Amendment. And states that a refusal to sell real estate and contract for real estate in an equal way with a person because of race is a badge and incidence of slavery, and thus is prohibited by the 13th Amendment, even against private discrimination. So, there's another way it helps out.
Well, thank you all so much for joining us this evening, and please thank Danielle Howard-Walker. I'm sure there are additional questions that you have, and I'm sure you'd be happy to hang around for a bit and answer them. And please join us tomorrow, Saturday, and Sunday for the rest of our program.
Where will you be signing books?
Books?
Where are the books?
They're right outside.
Oh, perfect.
Thank you very much.
Thank you.
Really enjoyed hearing you. Thank you. Thank you. Thank you.
Yeah, this was really fun. I hope I'll see you again.
Yes, so good to see you.
See you again. Yeah, thanks.
Come on up.
Thank you so much. Pleasure. Thank you.